Topic today that is pretty complex. It's a topic that a lot of people are talking about, especially in college athletics. But what we're going to look at here is this: as NIL continues to evolve, it seems to bring up more questions, gets more complex. A lot of people saying, "Well, you got to do this, this, and this." And basically, what we're talking about today is kind of like you got a bit of a clash going on right now, right? You've got state lawmakers that are saying one thing. You've got the conferences saying something else when it comes to NIL. There are decisions that are being made, state laws, you name it, but it almost sounds like that when it's all said and done, and I'm going to have you kind of walk us through and explain this, but when it's all said and done, that schools like Tennessee, if they don't follow certain rules or follow one particular, they could find themselves outside of a conference, specifically, let's say the SEC, a conference that was founded right here in Knoxville. If you think about it, on Gay Street, right? So I guess first, get everybody up to date on kind of how this setup is playing out. The two sides, what's at stake here, what's going on?
Well, Tennessee once again finds itself at the epicenter of an NIL earthquake as the landscape is dramatically about to change once again in pay-for-play college athletics. The House settlement, that's the name of an Arizona State athlete, a swimmer, Grant House, along with others, sued the NCAA for not allowing NIL compensation when they were playing. So it was the precursor of what is now going to be a global restructuring of NIL. And basically, here's the nutshell of the House settlement, which has prompted Tennessee state law changes, has prompted loyalty pledges. But we are days away from this House settlement taking effect. The first thing it will do, it will impose salary caps on universities for NIL deals. Okay. Now, what does that mean? It doesn't mean a particular player can be paid a particular amount. It means the universities have a cap into how much they can allocate to NIL money. It will also allow universities to pay players directly, which has been the huge legal fiction in NIL from day one, where you could pay people for their name, image, likeness, but you couldn't pay them to come to a university. That's legal hogwash, gobbledygook, swahili. From the very inception, it was flawed, and that's not what that money was for. Third thing is roster caps. Another thing is there's going to be a clearinghouse to monitor genuine NIL deals. So fast forward, as this is getting ready to unfold, the Tennessee State Legislature passed a bill to give the University of Tennessee incredible power and protection from this House settlement. What they've done is, under this legislation, House Bill 536, Tennessee is not bound by any NIL salary caps. If the NCAA is sued for violating the Sherman Antitrust Act, they have to indemnify the University of Tennessee. If a player sues the University of Tennessee based on what the NCAA or SEC did, they have to be indemnified. Under the law, the NCAA can't punish UT for not complying. If UT feels that the new settlement rules violate state or federal law or create an unfair competitive advantage, we can pull out. So think about this. As the landscape's getting ready to change, we went to Nashville and said, not so fast, because if we don't like your rules, we're taking our ball and go home. But Bo, there's another layer.
Okay, I was going to say, I know there's another layer here.
So the other layer is, in response to the state legislature passing this law, and it was signed by Governor Lee just a few weeks ago, now the Power Five conferences and the NCAA have circulated a loyalty pledge and said, okay, if you're not going to follow our rules from the House settlement, then you may face expulsion from the conference. So think about this. We talked about an epic battle, and UT didn't blink when Amaleva wanted more money at the end of spring practice. Now, the NCAA and the SEC have said, you know, if you want to be an 800-pound gorilla and not play by the rules, you can walk.
And from what I understand, though, there's already been I guess an athletic director, not named specifically, but there has been one that has already stepped up and said, listen, if a school's not playing by the rules, we're not going to play them. So, right. I mean, that's already been thrown out there now as well. So now you're going to have different schools pointing fingers at one another, possibly.
It's going to change rapidly, and no one knows what's going to happen. And here's why Tennessee, I think, helped nudge the General Assembly to get this done. There is a feeling that after the House settlement is implemented, you are going to see a wave of litigation under the Sherman Antitrust Act, arguing that it still creates an unfair competitive advantage. And that's one of the reasons, if you read House Bill 536 real carefully, it says even during your tenure, let's say at the University of Tennessee, an athlete is still allowed to shop the fair market, still allowed to speak to other institutions. And I don't think they put that in there because they want players to leave. They just don't want to be sued by creating an unfair competitive advantage. So, Bo, this is going to be remarkable. Within a few days, we're going to see how the landscape of NIL changes and what UT's role, again, is.
Again, we're talking about universities here, conferences here, but you also have to think about there is a player, a student athlete who is caught up in all of this as well. One may allow them a little bit more freedom to go out and shop. Others say there's different rules. So, if you're a player, a student athlete sitting here watching this, what's going through your mind at this point?
Well, my mind is, in talking to people close to the university, they think that this House settlement is a first step, but the next thing we're going to see is a wave of litigation from the collectives, from student athletes, saying that the way the House settlement is being implemented creates an unfair competitive advantage. So I think what's going to happen, this is going to have to shake out. There's going to have to be a change in the federal legislation. There is going to have to be a case that addresses all of these issues. But until then, it's going to be a wild ride in just a few days.
I know you're talking about like in a few days, but you think this is going to all, I mean, you say a few days, but it sounds like to me this is going to take more than a few days to try to figure this out.
Well, it has. And let's talk about from a practical standpoint. Even though the Power 5 conferences, including the SEC, and everybody has floated out this loyalty pledge, like I promise to play nice and go by the rules, I really don't think that the SEC is going to expel a historic partner such as the University of Tennessee, and I don't think that the University of Tennessee is going to walk away from a Power 5 conference. I think what you're seeing right now is legal posturing as all this unfolds. But isn't it amazing, like with Nico Amaleva, when UT sued the NCAA and changed the landscape of pay-for-play forever, once again, UT is at the forefront. And the reason the loyalty pledge is being circulated is because the state law that was enacted a few weeks ago in Nashville.
Wow. Well, and you said you're talking about, the conferences and the power. There's always been that talk, too, at some point do these conferences kind of go off on their own? Is this now, is that kind of what we're seeing here as well? Could we see some alignment here as more of a power play posturing, if you will, by the conferences?
Well, I'm going to tell you this. I think these conferences are being legally hypocritical because at the last meeting, the SEC very quietly said if they don't like the way the NCAA is doing all of this House restructuring and settlement, they've got the power, they being the SEC schools, to walk away from the NCAA. So, I mean, think about it. It's like a huge Mexican drug deal gone bad. I mean, everybody's going in and everybody's saying, hey, if I don't, let me see your money before my money. Let me see what your settlement is. I'm going to walk. So it is really going to be remarkable at the end of the day for this settlement that was designed to create uniformity in pay for play. College athletics may have created more controversy than it solved.
It's interesting. I do want to ask you one more, and then we're going to wrap this up here. Does this go back to before we even got into all of this, when everybody's talking about, okay, we're going to start doing this now. We're going to open up the doors. We're going to let the NIL come. There need to be a better plan in place, right? I mean, it's almost kind of like everything opened up, and everybody started going, and it's kind of like there were no parameters set. There were certain laws, but who was going to monitor this? Who was going to do that? It kind of seems like some of this we could have taken care of some of this on the front end.
Well,
but here we are.
Here we are.
Yeah, going to see how this one plays out. All right, Greg, as always, thank you so very much.
Let's talk more after this break.
All right, is that what we're doing? We're going to a break. Okay, I saw someone pointing at a watch. Lori does this, so I'm just kind of going along with the flow. Stay with us. We'll be right back. All right, welcome back, everyone. Bo Williams with Greg Isaacs. We've been talking NIL and the latest developments concerning NIL, conferences, laws that are now being discussed and passed, and what this all means, and the possibility, according to Greg here, that schools could find themselves looking for a conference if they don't play by the rules. And something I wanted to bring up that we kind of talked about right before we went to the break, the fact that, how did we get here? We look at this, and I think a lot of fans are that way too. I think a lot of people are like, okay, we're going to start paying players, or players can get some money, but it just seems like it's more like the Wild West right now. There's not a lot of rules. They're trying to implement the rules after they already opened up the gates. So how do we get to this point?
Bo, it seems like we have been in the NIL metaverse for years, and it's only been a short period of time, and it sounded like a great idea. These college athletes that work real hard, that bring in millions of dollars in revenue, why shouldn't they be compensated for their name, image, and likeness? So, that started out to be a great thought from the NCAA. And I remember being in a meeting with a prior athletic director, with some athletes and a parent, and the parent predicted, in a few years we will pay, and this was under the Jeremy Pruitt era, we will pay college athletes compensation. And the prior athletic director kind of shook his head, and then, it was like we were talking, there's going to be Martians that are going to land. and then, lo and behold, you have NIL, but here's it was flawed from the beginning, because what was supposed to happen, you were to pay athletes for their name, image, likeness, and it was supposed to be tied to appearances, to endorsements, to internships. So to get compensated, you had to say, I'm somebody, please come buy cars from this dealer, I'm a University of Tennessee athlete. There was an explicit prohibition about paying students to attend a particular college or university. But, Bo, from the very beginning, it was like the old days when you paid money under the table, I hear. Not that I would have any personal knowledge. But basically that went out the window because people were being paid $1 million, $2 million, $4 million, $5 million, and it sure as heck wasn't to sell widgets or sell cars. It was to come to a particular university. So that legal fiction and that legal fallacy created this wild, wild west environment. And then, UT, again, has always been at the epicenter of NIL reform. When we sued the NCAA, when we were on the verge of being sanctioned for the way the collective paid Nico Amaleva, that opened things up even more. So that was a very historic, precedent-setting lawsuit in Greenville, where basically, UT, it's kind of like a bad football game. We kicked the NCAA all over the field and came out of there, and we revolutionized NIL. But the way we did it, there were basically no rules.
Yeah. Well, it's also opened up a lot of doors, as we've seen lately, to the back pay to athletes as well. Going back, I want to say it's to 2016, that some of those athletes are able to still get some money, even though they have not been playing, but their name, image, and likeness was out there. The funny thing, side note, my son graduated in 2015, who was a college athlete, so he gets nothing. It goes back to 2016. I told him, man, he should have hung around for one more year, but who knew back then? But it does go back and brings in those athletes as well, and they factor into this also.
And that's another part of this monolithic House settlement. There is $2.6 billion that is going to be redistributed to athletes because they weren't entitled to NIL. And I guess the 2016 is kind of arbitrary. Your son doesn't get it.
Just missed out.
A lot of people, like my good friend Todd Kelly Jr., is going to get some money. But basically $2.64 billion under this settlement. They're going to set up a entity or a board to kind of place value on what someone's NIL compensation would have been if you played here contemporaneously. There's going to be a branch that's going to oversee collectives, the way they sign NIL agreements. But the big thing is, too, universities can pay these players directly.
Right.
So a lot of changes, but how did we get here? We got here because at the very beginning, we didn't tell the 800-pound gorilla universities that you can't pay somebody $5 million and wink and nod and say we're not paying them to play football at University X. So I think at the very beginning it was flawed, and it has taken a while for it's like the proverbial the emperor has no clothes on. Everybody to say this system is broke and it needs to be fixed, and it needs to be fixed now.
All right. And on that note, we're going to take another break, and we'll come back, talk a little bit more with Greg Isaacs. Stay with us. All right, welcome back. Bo Williams along with Greg Isaacs. So just to kind of go back over, we're talking NIL, but really the next chapter, I guess, in NIL. And there's been a lot of chapters written in a very short amount of time, but basically one side of the contest, state lawmakers pass rules saying that colleges and players don't have to get tangled up in the rules a league or conference sets up. But then on the other side, governing bodies of college sports who've seen courts dismantle long-standing rules, then tried to, and often failed, to keep money from playing a role in student-athletes' decision-making processes. They're coming up with their rules. So basically you've got conferences, state lawmakers, you've got collectives, you've got there's so many different parties in all of this, Greg. Who blinks? Because like you said, this is about posturing is what this really comes down to, at least how you're looking at this. Who dictates what a school can and can't do when it comes to NIL. Who blinks in all of this?
Well, let's be very careful. Yeah. This is not about the college athlete. This is about billions of dollars in pay for play and revenue. And this all came about because the House settlement, which Grant House sued the NCAA.
Right. Again, just to reiterate, that's House is a last name.
It's a last name, not getting his NIL compensation. So here's what's happening in a few days. $2.6 billion payout for athletes 2016 forward. That's going to be administered by a independent body. Universities can pay and colleges players directly. There is going to be a salary cap, and there's going to be roster limits. In response, UT has said, not so fast. I think this is still creates an unfair competitive advantage under the Sherman Antitrust Act. So we passed a law and said, we don't have to play nice. We can not adhere to salary caps. We can not follow any potential rule from the SEC or NCAA that violates state or federal law, especially if it's a Sherman antitrust, anti-competitive provision. And we have the authority, and also NCAA, if we do get sued, you've got to indemnify us, and you can't tell us what to do unless it's through a court of competent jurisdiction. So think about that. We have a golden parachute. In response, here's who's going to blink. NCAA, SEC, Power 5 schools have circulated a loyalty pledge and said, if you don't agree to play by the new rules and disregard your state law, we are contemplating expulsion from the conference. So UT, through this whole saga, every time we're at the epicenter of NIL, the earthquake after earthquake, UT hadn't blinked. So it's going to be interesting now to see, does the SEC blink? Does the NCAA blink? Does UT blink? But it is kind of like nuclear detente. But everybody, and these are hundreds of millions of dollars. These are 800-pound gorillas that everybody is getting really nervous at the table. So these next few weeks in college athletics are going to be historic.
We keep talking about UT. Are there others? Have we seen other states? Anybody else?
15 states, Bo, have similar legislation, but Tennessee's is the most athlete-friendly of all of them and gives the most protection to the University of Tennessee in terms of potential lawsuits. We must be indemnified by the NCAA. We can legally disregard anything they say. And again, remember the power conferences snuck in a provision at their last meeting that they can withdraw from the NCAA if they don't like what they're doing.
Right. And that kind of went back to an earlier question we were talking about, is this more posturing to where the conferences, these power conferences may be, because it's always been out there. Maybe they just go off on their own. Is this an opportunity?
Well, let me
for them
give
to
you
do
an
that?
analogy about how bizarre this has become.
Okay.
It would be like getting married and right after the and at the time you say I do, sign a marital dissolution agreement and not date it. I mean, you know, it's counterintuitive that you're going to have a settlement and you're going to do this. But by the way, you know, we have the authority not to follow this settlement. We have the authority to do whatever in the hell we want to do when we want to do it. So, you know, if you're a conference, you've got to have control or you're not a conference. If you're the NCAA, you've got to be able to control college athletics.
Yeah.
But here's my prediction. My prediction is, as Mr. T said, is pain. You're going to see lawsuit after lawsuit after lawsuit. And I think what the big schools, the Power 5 schools, are going to do, you're going to regulate the NCAA to running March Madness, and you're going to let the big boys run college football.
What do you do if you're like the next five? You're sitting there looking at this. I mean, what's got to be going through your head? You know, you're looking at the big brother up here, the big schools, and they're doing all this stuff. And then you've got the mid-majors, if you will, who are sitting down here, and they're going, what in the world?
Just wanting kids to play college sports and make good grades and go out and have a job. Yeah, they're just kind of watching, going, you know, look at all this
the
craziness.
FCS and those schools have just got to be sitting there thinking, what in the world? How is this going to trick? At some point, there will be a trickle down. You have to think. I mean, I know that's down the line, but there's got to be some type of effect.
The way this is going to be fixed is the way Congress fixed baseball when they had anti-Sherman trust issues. You know, just turn the TV on Sunday and ask yourself how professional football players are paid and compensated and how it works. That's a good model, but something is going to happen, and I don't think the House settlement's the answer. I don't think the Tennessee state law is the answer, but we're getting closer to something.
I'll say, are we getting closer to, is it almost like another minor league, though, even though some of these salaries are more like major league salaries that some of these players may be seeing?
And you know, you talk about the law of unforeseen consequences. It's more lucrative for college athletes if you're successful to stay in and receive your NIL money than turn pro and get your rookie salary cap money.
Well, we've seen that too with some players saying, you know, I want that extra year, and you know, maybe their draft prospects really aren't as high as some of their teammates, and here's an opportunity. They will probably make more instead of going into the minors or going over to Europe or somewhere else to play, whether it's basketball, football, baseball, what have you, to get another year of college sports.
Well, it's you know, a good example. Ewers, the Texas quarterback, turned down $7 million in NIL money and was like at the bottom of the draft. Deion Sanders' son, another good example that would be making probably more NIL money than he's going to make for the Browns. So, interesting story, but the next few weeks in college football are going to be historic, and they're going to be defining. But once again, Tennessee's at the epicenter of this earthquake. And, Bo, I would not be surprised if Tennessee does not back down if they feel there is a settlement or rules that they don't think is for the best interest of their students, student athletes, or violates the Sherman Antitrust Act.
Let me ask this real quick. We have about a minute and a half left to go here. If I'm sitting out in the audience here, right? Okay, we're in the courtroom. We got all these different players, right? And I'm sitting in the audience. What should I be looking for, listening for? If I'm in the jury box, what have you? What should I be looking for? Someone on the outside looking in at this as we get closer, like I said, the next couple of days, weeks, this is all going to come to a head to some type. What do I need to be looking for here?
Well, what you need to be looking for is, first, once the House settlement becomes final. Second, what the NCAA does to codify that settlement.
Okay.
And third, whether universities like UT say, we're going to play ball. No pun intended. So that's what I would look for. But the first sign that this is all two things that shows this is going to crumble, if there's immediate litigation regarding the settlement saying it's violates the Sherman Antitrust Act and creates an unfair competitive advantage, and second, if big universities don't sign the loyalty pledge.
Okay. Yeah.
Those two things are going to mark the beginning of the end at the very beginning. So those are two things I would pay close attention to as this emerges.
There. Yeah, who's putting their John Hancock on that piece of
well,
paper?
more important, who's not signing?
Well, that's true. Yeah,
the
who's
loyalty
going to hold
pledge.
out? Yeah, and not be a part of it, and then see what happens after that. Greg, as always, I have a feeling this is a topic we're going to be talking about again down the line. That is for sure. It is not going anywhere anytime soon. But we do appreciate your time. And again, Greg, as always, we appreciate you coming in as well. It's a complex matter. There's a lot of players here and a lot of things going on. But we appreciate you coming in, kind of ironing this out, and at least giving us an idea of kind of what to look for as this one moves forward now.
But what you look for is see the first person that blinks.
That's right.
It's like a poker game.
It is. It exactly is what it is. All right. Thank you again so much. We'll do this again next week as we always do, and we look forward to seeing you then.